You are listening to the Justice in Heels podcast with me, your host, Danielle Hayward. Join me as I discuss interesting legal topics with inspiring female legal professionals who paved the way for the rest of us.
A warm welcome to another episode of the Justice in Heels podcast. Today, I am joined by Karen Botha, who is a mediator. Karen, welcome to the podcast.
Yeah, thank you. Thank you for having me.
So, before we start with the topic of mediation, can you maybe just tell our listeners a bit more about yourself?
Yeah, sure. So I'm a practicing attorney. I am a CEDA UK accredited commercial mediator, and I'm an accredited parenting coordinator. In my law practice, I specialize in family disputes, but my mediation is really my passion, as I believe that almost every dispute is capable of alternate dispute resolution and that litigation should be avoided wherever possible. So yeah, that's a little bit about me.
So, for the listeners who may not be familiar with the concept of mediation, could you maybe just explain what is mediation and how does it differ from other alternative dispute resolution?
All right. So mediation, arbitration, and litigation are all very different forms of dispute resolution. They're all forms of dispute resolution, but they differ slightly. So litigation, of course, is when you go to courts. It's very formal. It's adversarial. There are very strict rules and procedures that must be complied with. So whether you're at the High Court or the Regional Court or the Magistrates Court, they all have their own strict rules. They're very similar rules, but they give you very strict timelines and all of that kind of thing. Importantly, the outcome in litigation is decided by a single judge or a magistrate who makes a decision that's final and binding on the parties. So that's a very important thing when I speak about mediation now. Arbitration, on the other hand, is most simply explained as essentially private litigation. So instead of the parties going to court, they jointly appoint an arbitrator, and then the arbitration takes place in a private venue. So it could be an advocate that's appointed, and they will go to the advocate's chambers and they will do the arbitration there. The parties then pay the arbitrator a fee, whereas a judge or a magistrate gets paid by the government. The parties don't pay the judge or magistrate. So like with litigation, the arbitration award is final and binding on the parties. Although the process is slightly less formal, the pleadings and exchange of documents in arbitration is done using the court rules and the same laws of evidence and that sort of thing as are used in court proceedings. Mediation, on the other hand, is completely different. Firstly, mediation is voluntary. So both parties must agree to mediate, and so they can't be forced to mediate. And once they've agreed to mediate, they then jointly appoint the mediator. So they decide who the mediator is going to be. So in mediation, the mediator is an independent and impartial third party. And that mediator doesn't make any judgment calls or decisions on behalf of the parties. The process is very informal and flexible, so it's adaptable to a variety of situations. There's no strict rules that have to be followed. And most importantly, whilst the mediator controls the process of mediation, the parties ultimately control the outcome. So that's where it differs completely from litigation and arbitration. The parties remain in control.
So, there are some cases where the court require the parties to actually first mediate before they can litigate. Can you maybe just tell us in which or what type of cases that will be the case?
All right. So it's still very, very rare that parties are directed to mediate. With the recent amendments to the court rules, so we've got section 41A, big A, of the High Court rules and Chapter 2 of the Magistrates Court rules, the parties are essentially required to indicate whether or not they're prepared to mediate. So it doesn't actually mandate them to mediate. They still have an option. They have to file a notice, and in that notice they can say, I agree to mediation for these reasons, or I don't agree for these reasons. So Rule 41A defines mediation as follows. It's a voluntary process, so voluntary, entered into by agreement between the parties to a dispute, in which an impartial and independent person assists the parties to either resolve the dispute between them, or identify issues upon which agreement can be reached, or explore areas of compromise, generate options, resolve the disputes, clarify priorities, by facilitating discussions between them and assisting them to negotiate. So Chapter 2 of the Magistrates Court rules is similar, not exactly the same, but similar. But the main thing is that it remains voluntary. And if one of them chooses not to mediate, the important thing to remember is that the court, if it goes to trial, and one of the parties has said, no, I'm not prepared to mediate, the court may grant a costs order against the person who said they're not prepared to mediate. There have been a few judgments about that, so that is important to remember. The Children's Act is one of the acts that does mandate mediation in two specific cases. The one is where an unmarried couple are having a dispute about whether or not the father has complied with the provisions of the Act in respect of parental responsibilities and rights. And then the Children's Act provides that the parties must be referred for mediation to a family advocate, a social worker, a social service professional, or other suitably qualified person. It doesn't define what a suitably qualified person is. And the other section is Section 33, which is now where the parties were married and are now separated, and they're having a dispute in regards to the exercise of their parental responsibilities and rights. Again, the parties must seek the assistance of a family advocate, social worker or psychologist, or mediation through a social worker or other suitably qualified person. Again, not defined. Then there's a couple of sections of the Children's Act that say that they may be referred to mediation, but it's not mandatory.
So I'm assuming that South Africa's diversity also play or has an impact on mediation. So can you maybe tell us how does the cultural diversity that we have in South Africa impact this mediation process?
Well, this for me is the wonderful thing about mediation. So firstly, mediation is nothing new to South Africa. It's been around for centuries in Africa. Okay, it's an African tradition. The whole concept of Ubuntu is sort of incorporated into mediation. So the great thing about mediation is that, as I said before, the process is completely flexible. So it can be managed to accommodate things like cultural diversity, religious beliefs, because often you'll find a dispute between parties who have different religious beliefs. It can accommodate people's family and work commitments. So essentially any situation can be accommodated through mediation, which is so different to the courts where you have to follow these set proceedings. That said, mediators in South Africa must be culturally competent and aware of the various cultures, historical and social dynamics that influence disputes, because our disputes are very different to other countries where they don't have such a cultural diversity. So this involves not only understanding and respecting cultural differences, but also being able to integrate traditional and modern mediation practices to create a process that's fair and effective and acceptable to the parties that are involved. So cultural sensitivity, empathy, and adaptability are obviously key skills for any mediator working in such a diverse environment.
So, I mean, you then get to actually work with a lot of different cultures and people and like personalities. So do you as a mediator prepare before you are seeing like these two people or three people who want to mediate on something? Do you do something to prepare beforehand, or is it kind of like a flexible process?
So personally, I always do like an intake call with the parties. So I will speak to each of them independently of one another, and it's usually just a short telephone call so that they understand who I am. I usually do it by Zoom as well, so that they can see me face to face, because it's good to see who you're going to be meeting with. And then if there is a cultural thing, or a religious issue, I will specifically ask them about it. Because for me, it's very important. So I've had quite a lot of mediations involving, for example, Zulu people, because I'm originally from KZN. And I always ask them the question, would they not prefer a mediator who is Zulu and understands the Zulu culture? And that always results in a lively discussion about culture. And I love that because it gives me an opportunity to learn. And I love to learn about other cultures. And so that then gives the parties the understanding that I am culturally sensitive and I am interested. And then that breaks that barrier. But it can be quite a strong barrier if you don't approach it in an appropriate way.
Well, that's interesting. And I guess it makes sense because I mean, like, yes, you have to have a little bit of knowledge about the culture and like how they resolve conflict. But I think it's also nice to have someone who's like a completely impartial third person, to observe this situation. And I guess like you have a different perspective, so you can offer them techniques or like a different view that they may not have thought of before.
Well, so I think the most important thing to remember about mediation is that the mediator is there to listen and to actually hear the parties. And regardless of what your religious background may be or your culture may be, being heard is vital to people. They just want to know, like, they want to know that this person they're sitting in front of just gets them and hears them, because the person they're in a dispute with may be the same culture and the same religion, but is not hearing them. So they want to be heard. And I think as a mediator, if you can really hone your listening skills so that that person who's sitting with you, who's sharing like very deep, intense needs and interests, and is trusting you with that, it's a very trusting relationship that needs to be formed. So if you can hone your skills of listening and hearing what people are saying, then mediation is just, it's remarkable, because you can watch people go from literally wanting to kill each other to being able to sit around a table and say, I get you and you get me.
That's amazing. So, can you maybe share a memorable case where mediation has led to successful resolution and what made it so successful?
That's interesting. I mean, honestly, all my cases are memorable to me because I get to know, I'm dealing with people in their most difficult times. So I get to know so much about them that they probably would never have shared with with anybody else other than maybe a best friend. So it's a very unique privilege for me. But if I had to choose one, I think it would be a party who they were divorced and fighting over the care and contact of their son. And they didn't share much in common, including religion. So mom was Hindu and dad was Buddhist. So quite different views. And mom was angry at dad for his perceived failures as a father, and dad was angry at mom for trying to control and gatekeep his relationship with his son and limit his contact. I literally spent an entire day with them. We started about 8:30 and I eventually walked out probably about 5:30. And mom was there with her new partner. And as I got to know them a bit better, I started to realize that mom's issues with dad were not actually hers, but her new partner's. And he felt that he could raise a child better than the dad. So it was a very interesting dynamic that I had to deal with because I had the partner in the room. So by the end of the day, dad had basically agreed to everything that mom or her new partner was demanding. But mom just kept moving the goalposts. So I'd go back to mom and say, okay, dad's agreed with this, this, and this. And she'd say, yeah, but what about that, and that? So then I'd go back to dad and say, well, what about that, and that? And he'd say, okay, fine. So dad was agreeing, but mom was just confrontational all the time. So when I finished, I was really disappointed because I felt like although dad had agreed, mom just wasn't there and we didn't get to sign a parenting plan or anything. 3 years later, this year, I get an email from mom and dad saying they need to mediate again. And because they want to make changes to their parenting plan. And I'm like, parenting plan? What parenting plan? So they sent me the parenting plan. And the parenting plan that they eventually agreed on, which was literally days after the mediation had occurred 3 years ago, was almost identical to what we had discussed during the mediation process. But they didn't tell me that they'd signed it. And in fact, now the change that they wanted to make was that the little boy was going to go and live with dad. So that for me was quite remarkable that although it seemed like there was just no agreement coming from mom's side, they actually did agree and they did proceed to sign a parents' plan, which was fabulous to hear.
That's fantastic. Wow. So you've mentioned a lot of like amazing benefits of mediation, but can you maybe elaborate on that? Like what other benefits are there?
Sure. So there are many benefits. Most people will say the cost factor is the main benefits. And whilst that's true, there is generally a cost saving versus litigation, for example. I don't entirely agree because for me, being a litigation attorney myself, the main benefit to mediation is you stay out of the courts. And any litigation attorney will tell you that court proceedings are a nightmare. So I go back to what I said earlier about people wanting to be heard. So many people who come to me to litigate, they will tell me they want their day in court. They want to be heard. What they don't necessarily understand are the obstacles that are in their path getting to the day when they're going to go to court to be heard. So, for example, the length of time it takes to get a matter ready for trial, and then the time it takes to actually get a trial date. So, for example, in the High Courts here in the Western Cape, for example, it could take you up to 4 years just to get a matter trial ready because of the hoops you have to jump through in order to get there. And in that process, there's a lot of procedures you have to follow. There's a lot of rules. There's a lot of documents that have to be discovered and trial bundles that have to be prepared. And all of that takes time and costs a lot of money. So, and once your trial ready, then it's going to take another year or two to get a trial date. So you're looking at a period of not less than 4 years and anything up to 7 or 8 years before you even go to trial. And during that time, you're embroiled and locked into this battle that's very adversarial. Then, of course, when you finally do go to trial, you now have to take days, if not weeks, off work or away from your business, which is another cost that people don't factor in to the cost of litigation. So the cost of litigation is not necessarily just how much you're going to pay your attorney and your advocate and any other experts that might be called. It's also the amount of time you lose. Preparation for trial, there's a lot of time involved in that. And then actually at trial, people don't actually realize. Then people say they want to be heard, but what they don't get is that they're going to have to undergo intensive cross-examination. And for anybody sitting on the stand is stressful, even for a very experienced expert. It's a very unpleasant experience, very unpleasant. And the role of the attorney, the opposing attorney or advocate, is to trip you up and make you, to find fault with what you are saying in your evidence, essentially. So it's very stressful. And then, of course, as I said before, after you've gone through all of that, you're now leaving that decision to one person, one judge, one magistrate, who's going to decide based on the evidence that you led and on your demeanor in court, something that may affect the rest of your life. For me, that's like, I'm not going to leave my future in the hands of one person. And so that's why mediation is so much better and where the benefits come in. So first of all, it can be arranged really quickly. I mean, you could come to me today and we could mediate next week. And the mediation can be done within days or weeks at the most. Provided the parties have good intentions, of course. Sometimes it takes a little longer because you've got to get past all the bad intentions, but generally speaking. And so, again, I go back to remember that the mediator who's properly trained is actually going to hear you. They're not there to judge you. They're not there to cross-examine you. They're there to listen to what you have to say and to help you to express and communicate your needs and interests in a way that the other person can hear. Another important benefit is that mediation is confidential. If you go to court, anything that gets put into that court file, except in child-related matters and domestic violence matters, anything that goes into that file is public, is available to the public. Anyone can go and access a court file and see what's in that court file. So you may have a huge financial matter where the parties are fighting about, business interests, for example. And they've now got to provide all this financial information that goes into the court file. Anyone can go in there and have a look at it. Whereas mediation, confidential. Nobody is allowed to disclose what was discussed at mediation. So that for me is very important. And then I think for me, the most valuable part of mediation is that the parties remain in control of the outcome because they are the ones that make the final decision. Are we going to agree, number one? And number two, how are we going to agree? No one's making that decision for them. And for me, that's incredibly empowering for a person. Particularly in a situation where you've got a massive power imbalance. So, for example, if you've got a boss and an employee, there's a huge power imbalance there. And mediation enables the mediator. The mediator can regulate those power imbalances. And that's so empowering for the employee, the person who's the more vulnerable of the two. So for me, that is the most important benefit, I think, of mediation.
So what are some of the emerging trends that you are observing in the field of mediation, specifically in South Africa?
Sure. Mediation at the moment, there's lots of exciting things happening. So, first of all, there's very lively discussion going on at the moment about mediation becoming mandatory. There are those for and against. those who are against mediation becoming mandatory obviously refer to the voluntariness of mediation, that it must remain voluntary. And then those who are for mediation being mandatory argue that it's still voluntary because they can terminate the mediation once the process is started. So there's quite a heated sort of, should I say, lively discussion going on about that, which is interesting. So it's going to be interesting to see how that rolls out. The South African Law Reform Commission are actually busy with a paper on that whole issue of whether or not mediation should be mandatory. So it's going to be interesting to see the results of that. The second issue that's caused very heated discussions is whether or not domestic violence matters should be mediated or are capable of mediation. In January of this year, the Department of Justice issued a circular directing their staff, of the DOJ staff, that they cannot direct parties to mediate, because it became evident that there were certain courts that were directing parties to attend mediation in domestic violence matters. So this has obviously caused a huge debate. A task team was formed by the DOJ, and there's research underway on that topic. So all I can say is watch this space. I don't know how that's going to play out, but it's definitely something that's happening very hot at the moment. And finally, and I think very importantly, is the issue of regulation of mediation. So at the moment, mediation is not regulated. There's no law governing mediation. There's no regulatory body. So essentially, anyone can profess to be a mediator. There's no law that says you must do X, Y, and Z course. There's no law that says you must come from a legal background or a health professional's background. There's nothing. So what that means essentially is that there's no regulatory body that's ensuring that mediators comply with a code of conduct or professional standards or anything like that. The HSPCA, they regulate medical professionals. The LPC regulates legal professionals. So we've got regulatory bodies that if you do something and you cause any kind of harm or you act outside of the code of conduct, you can get into serious trouble. So that for me is very problematic, because mediators are dealing with people who are suffering from trauma as a result of that conflict. And they can cause secondary trauma and further harm to people with no consequences for themselves. So that was one of the reasons why the DOJ stepped in with regards to mediation of domestic violence matters. So I'm very much for regulation, and I think most mediators and the profession as a whole and other professions are certainly for regulation. But again, that's something that's with the Law Reform Commission to discuss and draft a bill potentially for that purpose. So there's a lot going on.
A lot. So just to circle back a bit, in regards to the domestic violence cases, if you are comfortable sharing your opinion, do you think that domestic violence cases are like they can be solved with mediation, or do you think it depends on the severity and the type of domestic violence?
You hit the nail on the head. It depends on the type of domestic violence that's been allegedly committed. You must remember that, generally, and this is a generalization, but it is the trend, it's women and vulnerable people who are coming to the court for protection. They're coming there because they're saying, I'm suffering from domestic abuse, and this is the type of domestic abuse I'm suffering from. Now, mediation, remember, you're putting those two people in a room together. Now, you've got a victim and a perpetrator. That power imbalance is massive. You've potentially got someone who's being beaten or sexually assaulted by their partner. And in my view, you can never expect those two people to sit in the same room, because you are then causing further victimization and further traumatization to that victim. So my view is that there should be levels of domestic abuse. So where there's violence, physical violence or sexual violence of any nature, in my view, no mediation at all. Must go straight to court, and protection order must be put in place, and that must take its course. Where there's been things like coercive control, emotional and psychological abuse, which is enormously damaging, my view is that that must then be done by way of what we call shuttle mediation or caucus mediation, where the parties aren't in the same room. So they're kept completely separate. You know, on Zoom, you can create breakout rooms. So provided the parties are in separate rooms and there are mechanisms in place to protect the victim, then yes, there is a potential for, in my view, for that matter to be resolved through mediation. But as long as the victim feels protected and empowered. So yeah, you know, there are other countries that will not, that they, once there's domestic violence of any kind, mediation is out. So Australia, for example, if there's any domestic violence, no more mediation. And in Australia, mediation in family matters where there's children involved is mandatory. They have to go to mediation before they go to court, unless there's domestic violence. Then it's stopped. So there's a lot of other jurisdictions who have differing views, and I think South Africa needs to look at all of those and then come up with ways to protect our most vulnerable people. That's the most important thing. Protect our vulnerable, and then from there have an assessment tool that determines whether or not mediation is appropriate, and then what type of mediation would be appropriate.
Very insightful. Thank you for also sharing your opinion on this. But I mean, you've shared a lot of very valuable information today, but is there anything else that you may want the public to know about mediation?
Yeah, you know, mediation isn't mainstream. At the moment, it's still kind of, you know, skirting around the edges of litigation. So what I'd really like to ask the public is familiarize yourself with mediation as a form of positive conflict resolution. And understand that mediation can be used in almost any dispute. You know, if you're having an argument with your neighbor, why waste time and money going to court? If you can find a mediator, sit down, spend a day, discuss the matter, and resolve it in a way that can assist you to continue to have a relationship with that person. Because very often, people who are in disputes will have an ongoing relationship. So they, particularly family disputes, obviously, and they could be families who are disputing a will, for example, or, you know, who are living on the same property but not in the same house, but they're having a dispute over who parks their car in the driveway and who uses the garage. Those sort of things, there's going to be an ongoing relationship with that person. So mediation enables that relationship to be maintained and in many instances improved. Litigation is going to rip that apart. There's never ever going to be a relationship after litigation. It's just, you know, it's not going to happen. And honestly, I'm a litigation attorney. That's how I make my bread and butter. But it's soul destroying. I see what it does to people. Whereas when parties mediate, to see them walk out of the room with a smile on their face and feeling, well, I didn't have to take a winner-takes-all solution here. Maybe both of us didn't get exactly what we wanted, but we got the best case scenario that we could have got, rather than letting a judge say, well, here's the baby, I'm splitting it in half. And then everybody loses. So, yeah, I think really just if you don't know about litigation, find out, learn about it. And there are so many benefits that far outweigh litigation that it's important that people think about mediating rather than litigating.
Well, Karen, thank you so much for joining me on the podcast today. And thank you so much for all the amazing information that you shared with all of us. Where can our listeners reach you?
All right. So you can go to our website. I'm actually one of the directors of an organization called Dignified Dispute Resolution. And our website is www.disputeresolution.org.za. And on our website, you will find a whole array of amazing ebooks that we have put up that are free to download. And they cover every type of mediation or dispute under the sun. And you can go and read them and find out as much as you'd like about what types of matters can be mediated and how they're mediated. And then there's all our contact details are available on the website.
Thank you for listening to this episode of the Justice in Heels podcast. If you enjoyed this episode, feel free to share it with your friends on social media and tag us. As this podcast has a legal element, just a quick disclaimer that all views expressed in this podcast are not necessarily the views of the firms, companies, or brands that we are associated with. Until next time, goodbye.